Chapter 19 Breach of Contract and Remedies. There are multiple parts to this chapter, but the first one is damages. Remedy, relief that is provided for an innocent party when the other party has breached the contract. There are 4 types of damages: compensatory, consequential, punitive, and nominal. Compensatory damages replace what was lost because of the wrong or damage. Standard measure is the difference between value of promised performance and the value of actual performance. Some standard measure can be incidental damages or sale of goods. Compensatory damages can be construction contracts that have been breached by owner-contractor or both the owner and the contractor. Consequential damages are special damages that result from a party's breach of contract. Special circumstances would cause a non-breaching party to suffer additional loss. Punitive damages, not available for breach of contract. They may be available when an action can cause both a breach of contract and a tort. Nominal damage is when there is no financial loss. Mitigation of damages is the duty of innocent injured party to reduce the damages that a person has suffered. Rental agreements. Landlords must find a new tenant if the previous tenant defaults on rent or abandons the place. Employment contracts. A person that was wrongfully terminated owes a duty to take a similar job. Liquidated damages. A certain amount agreed to be paid as damages. Penalties. Designed to penalize, they are mostly unenforceable. Equitable remedies is another part in this chapter. Restitution. To rescind a contract, both of the parties must take a restitution to each other by returning goods, funds, and property that were previously conveyed. Specific performance is an equitable remedy that calls for the performance of the act promised in the contract. Reformation is an equitable remedy allowing a contract to be reformed to reflect each party's true intentions. Recovery based on a quasi-contract is another part. Quasi-contracts is a legal theory that is under an obligation which is imposed in the absence of an agreement. Waiver of breach. Waiver is knowing relinquishment of a legal right to require satisfactory and full performance. Reasons for waiving a breach. They are waived to obtain whatever benefit is still possible out of the contract. Contract provisions. Exculpatory clauses is provision stating that no damages can be recovered. Limitation of liability clauses is provisions that affect the ability of certain remedies. Enforceability of limitation of liability clauses is the exclusion of liability for fraudulent or intentional injury. Illegal acts or violations of law will not be enforced.